Professor John Spencer, CPQC. John is a Cambridge academic lawyer specialising in criminal law. On my left here is Alex Chalk, who is Member of Parliament for Cheltenham. He is a barrister by background, and I'm very delighted to welcome you tonight, Alex. Thank you very much for coming. On my right is Chris Chope. Sir Christopher Chope is a Member of Parliament for Christchurch, and over here we would see Gunnar Breck, again making his debut as volunteer. Gunnar is an EU lawyer, and he is both a barrister and an academic lawyer.
I was asked to speak for 10 to 12 minutes and no longer. It's a large and complicated topic, and I can't be more than very schematic in that time. I see people in the audience who know a huge amount about this topic, and I must apologise in advance for not telling them anything they will already know. I was a Remainer, but I accept that Brexit's going to happen, and we need to have a constructive and informed approach to where we go next in the area of criminal justice as in anything else. The title of this seminar today is slightly misleading. We can't help but leave behind the EU criminal justice package because all the relevant legal instruments will automatically cease to apply to the UK when it leaves, either on the date in March next year or at the end of a transition period. And so the choice the UK in most cases is faced with is between crashing out of the present arrangements without replacement and trying to negotiate some new arrangements, and the new arrangements might differ from the present arrangements or seek as far as possible to replicate them. And I think what we are going to try to talk about tonight is whether we need to try to replace them at all, and if so, if we need to replace them with something that replicates them or something significantly different. There's one initial point I'd like to make, because some people certainly have misunderstandings about it. Some people represent the EU's criminal justice package as the first steps towards a single unified criminal justice system for a future EU superstate, in which everybody will be forced to have the inquisitorial system shock horror like they've grown under in continental Europe. I only mention that because you do read it repeatedly in the newspapers, or some of the newspapers, and it absolutely isn't true. All the measures in which the UK is currently involved are horizontal measures intended to enable the member states to deal with the problem of cross-border crime effectively with their own criminal justice systems, not by requiring them to change them. And in setting this package up, the UK, mainly under the Blair government, took a leading part. And it took a leading part in it partly because it could see the way we do things in the UK, where we have 3 different criminal justice systems: England, Wales, Scotland, Northern Ireland, and work with mutual recognition and so forth between them. And the package was created for practical, not ideological reasons. An unwanted consequence of globalization, of which the EU's free trade and free movement policies are just a part, has been an increase in transporter crime, for which the previous arrangements were inadequate. And abandoning the current EU package without replacement might cause no problems if on Brexit the UK were to seal itself off from the rest of Europe and everybody else like a sort of European North Korea. But a future settlement, even if it's the hardest type of Brexit, is likely to retain at least some elements of free trade and some elements of easy travel and some elements of free movement, and with them inevitably some of the problems of transporter crime that we have. And this suggests that replacement measures of some sort are going to be required, and if we didn't have any, and just crashed out, we'd be in something of a mess. We talk all the time about the European arrest warrant, and a couple of statistics about that. In 2003, the last year before the European arrest warrant began, the UK received 114 extradition requests from the whole of the world and handed over 55 people to the whole of the world. And the UK issued just 87 extradition requests to the whole of the world. But in 2015, the UK received no less than 12,613 European arrest warrants, handed over 1,149 people to EU member states, and issued 228 requests, under which it got back 123 people. The European arrest warrant, just to take one example, as a number of the elements of the EU package, is hugely more efficient than the measures which it replaced, and we'd be in some significant trouble without it, not only getting people back from other countries to which they fled or in which they lurk after committing crimes in the UK, but also getting rid of people who've come here having committed crimes elsewhere. I heard a police officer say once, all about these things, without the European arrest warrant, we'd risk becoming the Brazil of Europe. Though replacement measures could in principle be negotiated separately with each member state, the only practical solution is a new treaty or set of treaties, probably treaty concluded with the EU collectively. And this is possible under the relevant provisions of the TFEU. Part of the package is Europol and Eurojust. These are information sharing organisations, not enforcement organisations. Europol for the police, of course. Eurojust, as I expect nearly everybody, or probably everybody here knows, is for public prosecutors. And with them, it's possible for states that aren't member states of the EU to have an association agreement. And it wouldn't need a new treaty for the UK to have an association agreement with, say, Eurojust or Europol. But if that happened, it wouldn't be in the same position as it is now. We wouldn't have a UK director of Europol, we wouldn't have a UK president of Eurojust, both of which we either have or have had. Key elements in the current criminal justice package are the mutual recognition instruments, requiring the criminal justice authorities of the member states to enforce each other's judgments and orders, like the European arrest warrant just mentioned, and of course the European investigation order, which has just come in, plus a lot of other backup measures of police cooperation and sharing of information and so on, which I haven't time to list. The European arrest warrant, which is the one we always end up talking about, has been criticised in this country for two reasons. First, because of its use in minor cases puts needless strain on our police and courts. Stories about Polish European arrest warrants for people who've stolen doors or made off without payment from a petrol station or something. And secondly, because it sometimes forces British citizens to face continental justice, a product said by some to be inferior to our own. Actually, very few British citizens are among those who get handed over. But a brief aside on that point, I know we're accustomed to saying in this country, British justice, which is the envy of the world. I haven't actually met many continentals who told me they pretty strongly envy it. And just as we have things that we don't like about quite a lot of continental criminal justice systems, so a lot of them have things they don't like about ours. The Swede once said to me, when your compatriots start talking about the superiority of the common law, I silence them with two words, Birmingham 6. And among other things they don't like, or some of them are unreasoned verdicts from juries, and the fact that you hardly ever get any compensation if you're held in prison before you're acquitted or before the Court of Appeal quashes your conviction, and so on. We could seek to replicate these measures, for example, the European arrest warrant, with new measures which sought to answer some of these objections. So, for example, to exclude British citizens from surrender under a new European arrest warrant. The problem with that is any concessions of this sort would almost certainly entail equivalent concessions in return. One of the problems with the arrangements before the European arrest warrant within Europe were that a number of the big states had a policy of refusing to extradite their nationals. The UK didn't. In fact, it hardly ever happened because we made it so complicated and expensive. It didn't happen except once in every third blue moon. But nevertheless, a number of other countries had it, and it caused a severe problem because if it was to Poland or France or Germany, they'd say, okay, this is a Pole or a Frenchman or a German. We'll try him here, just send the case over here, please. And very often it meant that the case couldn't proceed any further. The other thing is that new treaties presuppose negotiations, and negotiations in which the UK might or might not be able to get exactly what it wants. And I'll run out of time in a minute, but for example, if we want to have a Brexit under which we don't want to have anything more to do with the European Charter of Fundamental Rights, and with the background that we might possibly wish to withdraw from the European Convention on Human Rights, then I can see we might have trouble. The mutual recognition instruments work on the basis that you automatically accept the order from the other country unless certain bars to doing it are present. And that system operates on the basis we can trust each other's systems to operate within a certain framework of decency. And I can see possible difficulties from other member states and the Council and the European Parliament trying to negotiate something in which we didn't have any overt acceptance for the future of those. However carefully drafted, a new treaty, like any other treaty, is likely to throw up unexpected points of interpretation on which some court somewhere will eventually have to rule. And it's desirable, obviously, that the ruling should come from a single court whose rulings are accepted by all the parties concerned. I suppose in theory the UK could try to persuade the EU countries to accept for this purpose the rulings of the UK Supreme Court, but I don't think they're likely to accept that. The obvious court, in my view, would be the EU Court of Justice, as it is now, and I have difficulty in understanding the government's up to now strong red line on recognising the jurisdiction of the European Court of Justice. I think the government's insistence up to now on this is partly based on a failure to understand the rather limited role the court plays. Contrary to popular belief, it's not a further court of appeal to which prosecutors and defendants throughout Europe can take their complaints and crush the decisions of the courts of the member states. Its role essentially is limited to contravention proceedings brought by the Commission against member states which have never got around to implementing EU law, and secondly, responding to preliminary references from the courts of the member states who aren't sure what actually to do in the light of this, that, or the other piece of national legislation against a background of an EU instrument. For example, one that was decided, I think it was about 18 months ago, is it open to a member state, when confronted with a European arrest warrant, to say, well, we're not going to hand him over because we have evidence that the prison conditions of this country are so atrocious it would be contrary to Article 3 of the European Convention on Human Rights. An answer from the European Court of Justice, a little reluctantly, yes, basically, if they really do have the evidence. It might be possible to sort things out with a treaty which, like the EU instrument sort of replicating European arrest warrant for Norway and Iceland says that the courts will take notice of the CJEU's case law. I suspect that the UK courts would do that anyway, whatever the treaty said, and if the EU would accept that when dealing with the Norway and Iceland proposals, then I think would very likely satisfy the EU. But I expect most of us will have read the Prime Minister's speech in Munich the other day, in which there seems to be a certain backing off from previous strong resistance to have anything to do with the CJEU, where she says the treaty must, etc., be respectful of the sovereignty of both the UK and the EU's legal orders. So, for example, when participating in the EU agencies, the UK will respect the remit of the European Court of Justice. That, I suggest, is the way that we shall have to go for the future. Thank you.
Well, thank you very much. Thank you very much for inviting me, and it's fantastic to see such a group here. Seeing as we're talking about crime and law and order, I thought did come to mind that anecdote. You know that anecdote about Michael Howard? So he goes along to HMP Wandsworth apparently, and he's there, and the governor says to him, Home Secretary, we'd like you to address the prisoners, please. He says, what? No, really good. And so they're all ranged in front of him, a bit like you are now. They look up at him. He doesn't know quite how to begin, so he looks at them and says, I'm delighted to see you all here. And so I am too. I am absolutely delighted to see you all here. Thank you for having me. Forgive me if some of what I say actually does replicate what's been said, but it does bear emphasis. So the first question, EU crime and policing measures, is it time for the UK to leave them behind? Well, the short answer is yes, because as we've already heard, that follows from the decision. There is no choice. The various measures are contingent on membership. But the bigger question is whether there's an imperative in the UK, consistent, by the way, with the decision that has been made, to see the substance of those arrangements endure. And I would suggest that, broadly speaking, they have worked in the UK's national interest. They've enhanced overall national security and the fight against crime. And it's also tolerably plain that as Home Secretary, Theresa May's consistent instinct was to come down in favour of criminal justice cooperation, notwithstanding that may have carried with it an element of pooling of sovereignty. And where she did so, those decisions were backed by the NCA and ACPO. And I do think it's worth considering, when we debate this question, the political context and temperature here. For the most part, my judgment is, you may have different judgments, but that this kind of cooperation between EU member states has been broadly, not entirely, but broadly politically uncontroversial, even though it has involved that measure of pooling sovereignty. And I think it's reasonable to say, and this I'm sure will be controversial, but why not, let's start. If the EU was simply a union limited to cooperation in crime and policing, I venture to suggest that it's unlikely that the British people would have voted to leave. So I would suggest it wouldn't be to betray the referendum result. And by the way, any suggestion of betraying the referendum result, despite me being a Remainer, I think would be a huge folly. We have a duty to respect it, and I certainly will continue to do so. But it would not be to betray that result, that even if sovereignty were pooled in the future, that we should cleave to the view that the security dividend will outweigh the sovereignty deficit. So the security dividend will outweigh the sovereignty deficit. So I'll just take a moment, if I may, just to look briefly at some of these measures. We've heard about the European arrest warrant, broadly successful, as I say. The most famous case, perhaps, is when we retrieved Hussein Osman, who had fled after the 2005 bombings to Italy, and he was brought back on the order of an English court. It is, of course, true to say that there have been occasional shortcomings. Let's be absolutely blunt about it. A British national, Andrew Symeou, held in pre-trial detention for 11 months in Greece before his acquittal when it emerged that the evidence had been improperly obtained. Polish courts, as we've already heard, do have a tendency to issue warrants arguably too readily. But hard cases make bad law. The overall indication, a general consensus, is that in the main it is operated broadly as intended. And the NCA, no less, has said that leaving the EAW would pose a huge public protection risk to the UK. And interestingly, the current Home Secretary, Amber Rudd, said, 6th of May 2017, it is a priority for us to ensure that we remain part of the EAW. And I can assure members in all parts of the House that our European partners want to achieve that as well. The real question is, well, how? And I'll come back to that in a moment. Second, just a brief one, ECRIS, the European Criminal Records Information System. Through that, the UK exchanges tens of thousands of pieces of information about criminal convictions each year. SIS2, that's to say the Schengen Information System, gives the UK real-time access to all EAWs and other alerts. And again, the NCA says that loss of access to SIS2 would seriously inhibit the UK's ability to identify and arrest people who pose a threat to public safety. And there are a bunch of things which are coming down the line as well, which I think it would be in the UK's national interest for us to be part of. PRUM, for example, a regime for exchanging biometric information and vehicle registration data to reduce the time to find matches from tens of days currently to 15 minutes. That's what the NCA says. And as somebody who's had experience of being in court and prosecuting people, I can tell you, if you're able to put before the court previous convictions of an individual who's up for a sentencing hearing, that's enormously powerful and, at the risk of stating the obvious, can ensure that justice is done. So then there's European investigation order, and I'll just mention that briefly. This is more controversial because, of course, what it could involve is other states effectively mandating investigations to take place in the UK. But who was it who was Home Secretary at the time that this was considered? Theresa May, of course. And she addressed those concerns about sovereignty. She said there must be a clear link between the alleged criminality and the assistance required. Otherwise, as she put it, complying with the request would be in breach of Article 8 of the Convention. Now, who objected to that? Bill Cash. He protested, and she, Theresa May, responded with uncharacteristic, you may feel, bluntness, stating that he was, quote, wrong. And when Jacob Rees-Mogg invoked Margaret Thatcher, exclaiming, no, 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 she responded, is my honourable friend really saying that he wants us to hamper the efforts of our police to bring police to justice and fight crime? I sincerely hope not. This measure will help the police to ensure that justice is done and crime beaten. ACPO mentioned that it offers practical help to police and prosecutors, and every single chief police officer said we should opt in. So that's the context that when those decisions were offered in the past, our current Prime Minister came down in favour of opting in. But it's also worth recalling that EU cooperation on crime and policing goes beyond merely the European Arrest Warrant, ECRIS and the EIO. I'll just give you one issue. Europol, which of course provides analytical and operational support to national law enforcement authorities. The NCA, interestingly, brands Europol as the top priority to include in Brexit negotiations. But let's just pause for a second to think how that might work, because Denmark is not a member of Europol, because like us, it negotiated a Lisbon dispensation, but they managed to secure one which lost them the option to opt back in. I'm not quite sure why they did that. But anyway, Denmark's a third country. And so, although it does have observer status on Europol's management board, that is purely predicated on the fact, first, continued EU membership, and second, an obligation to fully implement into Danish law the relevant EU directive on data protection. I'll come back in the end to this business about data protection, because I see that as a potential rock upon which these negotiations, if not founder, will have to be negotiated. I'll come back to that in a moment. So we know that the government wants to do this. In the Florence speech, which now has this sort of quasi-religious status, she said she wanted a bold new strategic agreement which provides a comprehensive framework for future security, law enforcement and criminal justice. And at the Munich Security Conference, she said something similar, which was interpreted by ministers as saying they wanted it to be as close to the status quo as possible. So in the time remaining to me, how do we achieve this? So if we want to achieve the substance, how do you go about doing it? Well, by a treaty, of course. That's the obvious way of doing it. But the fact is there is no precedent for access by non-EU countries to ECRIS or non-Schengen countries to SIS2. And no doubt that lies behind the assessment of the House of Lords EU Committee that a cut and paste arrangement is, in its words, particularly ambitious. And I think if the UK wanted to deal with those hard cases that I was telling you about in the European Arrest Warrant, if, for the sake of argument, we wanted to get to a situation where we could refuse to extradite our own nationals, in other words, we wanted to claw back some of that sovereignty, well, I think we would cause ourselves some real difficulties. Why do I say that? Because if you look at the extradition agreement agreed between Norway and Iceland, neither of which is a member of the EU and the EU, negotiations began in 2001, concluded in 2014, still not in force. So I think if we seek to amend the arrangements, I think we will run out of time. A couple of final points on this data sharing point. One of the key consequences of being a third country is that it's likely to be necessary to show compliance with EU data protection standards as a precondition for exchanging data for law enforcement purposes. In plain English, they're going to want to be satisfied that if there are EU nationals in the UK, for example, that data has not been obtained in a way which offends against their standards of data collection and storage. And why is that relevant? Because if we seek as part of some treaty an adequacy decision from the EU, namely to say, well, don't worry, folks, the arrangements that we have in the UK are broadly similar, they're adequate, nothing to see here, can we continue to have our arrangements? That might be fine, but for 2 points. One, such a certificate of adequacy doesn't last in perpetuity. It lasts for 4 years. So this issue, even if we get an arrangement which allows us to continue to cooperate, this is going to come round again. It's going to come round again and again. And the other potential fly in the ointment is that Europe seems to be moving towards a position on data which we may not be comfortable with in the future. I'm thinking, of course, about the GDPR. You'll be familiar with that, the General Data Protection Regulations, which, according to the blurb, is to give control back to citizens and residents over their personal data and to simplify the regulatory environment for international businesses by unifying that regulation within the EU. In plain English, it's much more onerous. And the complexity is that that regulation will inevitably be engaged in the transfer of data for law enforcement purposes. Now, what if they turn around and say, actually, do you know what, we think you've diverged. We think you diverge, what happens then? And what happens also if they say, in order for us to make an assessment about whether you aren't converging, in other words, in order for us to make an assessment about whether you are converging, we need to see what people like GCHQ do. Of course, that was tried in the United States, and the United States was not terribly excited about allowing that degree of access. That could be an issue for the future. So, in a nutshell, we're leaving, so we need to replicate, if indeed there's a political view that we should. I think overall there's a general view amongst the population that it would be a sensible thing to do, but it's more difficult than it sounds. And furthermore, even if we do achieve it in the short term, don't be gulled into thinking that this is an end of it. This is an issue which will come up again and again and again, and we've got to be ready to deal with it when it does. Thank you.
I'm going to address you from here. The first two speakers were Remainers. I was very much a Leaver, and I still share great enthusiasm for the prospect of us being able to take back control over our own laws and our own borders and our own democracy. And the first two speakers, I thought it was interesting that although they pay lip service to the fact that they accept the result of the referendum, they didn't exactly show much enthusiasm for the prospect of us once again being able to take control of these very important issues for ourselves. And so I'd like to start off by saying we've got perfectly sensible arrangements with other countries in the world, including the United States, including a lot of the Commonwealth countries, for extradition, normally based upon the principle that you have to establish a prima facie case before you can do extradition, which I think fits in with the English common law tradition. Why do we need to continue to tie ourselves to the European Union rulebook and the European arrest warrant, which it was conceded that there had been some miscarriages of justice with the European arrest warrants, but it doesn't really matter too much because on the whole, it's been more useful than being unjust. I think that every miscarriage of justice as a result of the European arrest warrant is a really serious blight on that system. And at the moment, we still know about the Adamescu case. We've got the politicisation of the Catalan people in Belgium. Any number of cases caught up under the European arrest warrant being used for improper purposes, in my view. If we want to have security cooperation across Europe, and who doesn't want to have that? And this is what the Prime Minister was saying in her Munich speech. Let's concentrate on dealing with the terrorist threat. So let's enter into mutual arrangements so that we can have quick access to justice and quick arrests for people who are charged for terrorist offences. Why don't we separate those terrorist offences out from everything else? And this opportunity to readdress all this issue is, I think, one which we should seize. Just concentrate on the real threats to national security rather than trying to drag everybody else into the net. But people who think that the European arrest warrant is really some sort of perfect system, I'm just going to give you the example of one case reported from the Irish Times on the 24th of November 2017. Thomas Joseph O'Connor was sentenced to 4.5 years in jail at Blackfriars Crown Court in London for defrauding HMRC of tax. He actually was involved in a construction company director in a £5 million tax fraud. However, O'Connor was not there to hear the judge's words. The 49-year-old had been convicted earlier of the offence after a 6-week trial, but left for Ireland before the sentence was handed down. He'd been arrested in Ireland under a European arrest warrant in 2009. So this is a case reported in 2017. So it was hardly a speedy process, was it, under the European arrest warrant to get him here. The High Court ordered his extradition. He appealed. The Court of Appeal dismissed his appeal in October 2015. He lost a further appeal in the Supreme Court in March, and subsequently his lawyers returned to challenge his appeal, and so on. So he left the court when he was on bail and didn't appear for his sentence. He's still in Ireland, and his case is one of 20 or more extradition cases which are held up in Ireland now on the basis that because the United Kingdom is leaving the European Union, then it means that it will no longer be possible to get justice in a United Kingdom court without the backup of the European Court of Justice through the European arrest warrant system. And that seems to be absolutely ridiculous, but I'm told that a reference has been made by the Irish Supreme Court to the European Court of Justice for an opinion on whether or not, after Brexit, it will still be possible for the Irish to extradite potential prisoners to the United Kingdom. We know that other countries in Europe which are jealous of their own sovereignty, like for example Germany, they do not allow the extradition of any German citizens to third-party countries. So when we leave the European Union, they won't allow their citizens to be extradited to the United Kingdom. And I think this is a subject which lends itself very much to bilateral agreements, because I'm sure most lawyers in the room would accept that the system of justice in many countries, although they may be nominally in the European Union, the system of justice leaves much to be desired. And we've had a reference to Greece, one could refer to Spain or to Romania or to other countries without being too disparaging about them. But let's agree that there are wide variations in the quality of justice within countries within the European Union. And indeed, when I was in the Council of Europe on the selection committee for judges from across the 47 member countries in the Council of Europe, we often came across cases of judges, candidates who were far from ideal, one might say. They wouldn't have passed muster anywhere in the British system. So let's delude ourselves into thinking that everything's rosy under the European Union system. I think it's going to be great when we're going to be able to get out of all this and we're going to be able to dictate terms ourselves by mutual agreement. Let's see. see who wants to have arrangements with us on a mutual basis, and on the basis, I think, that you must have a proper prima facie case before somebody is forced to leave their home country and be sent to another country to face trial and potential sentence. And just to put all this in context, and our first speaker referred to some numbers, but in 2016, the United Kingdom made 349 requests for the extradition of individuals wanted across all EU states. So 349 requests in 1 year. So that's hardly, if we don't make any of those requests in the future under the European arrest warrant, it's hardly going to be the end of the world. And it's significant that other countries are making a lot more requests of us, which I think in itself tells a story. So my view is that we should look forward to being able to take control of this issue ourselves, as that we will be able to enter into won't need to be a treaty, but just arrangements with the European Union in relation to security and policy, particularly relating to terrorism. That should be reasonably straightforward. Let's make special arrangements, in my view, for terrorist suspects and terrorist cases, and don't let's have the abuse of the system which we've seen in this country when laws are brought in order to deal with terrorists, and then they're used to eject people from the Labour Party conference. We mustn't allow that sort of abuse to take place. So that's really my contribution to this, to try and introduce a bit of balance after our first two speakers, Sheila. But can I say that how much I appreciate all the work that you and your Politeia do on this and so many other subjects. And for those of you who haven't read Sheila's blog on Barnier's French logic, I commend it to you. I think it came out on the 2nd of February.
Thank you very much, Chris. I'm going to ask Gunnar Beck to act as rapporteur for these proceedings so that we can then throw it open to the House and you can join in.
Good. So what I'd like to do then is briefly say what I'm not going to comment on or what I agree with, and then I'd like to make 3 points, really. I should say, too, that I'm not a criminal lawyer, but I know a great deal about the ECJ, so the points I'd like to add to what's already been said will primarily focus on the ECJ. But let me first just recap on some of the points that were mentioned, and then briefly state my own view on this. Of course, I agree with Professor Spencer that EU criminal justice is a bit of a misnomer. Basically, there is EU criminal law, but it's generally concerned with cross-border measures. So I certainly agree with the proposition that this is not some covert attempt to introduce a common unified EU criminal justice system. Now, I also don't really have a view as to the comparative merits of various criminal justice systems, and what I'm going to say and the skepticism I'm going to voice about any future role of the European Court of Justice should not be taken as an endorsement of one criminal justice system as opposed to another. Thirdly, we've had some very interesting figures about the requests for European arrest warrant executions from the UK and the requests reaching the UK from the EU, and I agree with the view that I am not so sure that the heavens would fall in if, from the perspective of some people, the worst came to the worst and some comprehensive continuation to the present state of affairs weren't negotiated. Would cause some inconvenience, but the numbers we've heard suggest, as compared to having some trade deal as opposed to another, I don't think that's really can be compared. Now, perhaps a final point in relation to what's been said. The ECJ, Professor Spencer said, the ECJ is not a court of appeal. Of course it isn't, it's a court of reference. But I think it's important to realize that the Court of Justice, although not a Supreme Court or a court of appeal, does a great deal of what a court of appeal does and can do, and it can do a great deal more. It regularly quashes national laws on the grounds of their alleged non-compliance with EU law, and it regards itself and has generally been accepted as the sole interpreter of EU law, and in my view, and the view of many others, it is not the most impartial kind of interpreter of EU law. It consistently interprets EU law as in such a way that its competences are interpreted very broadly with the effect of nibbling away, little by little, at national competences. So I don't think it's an impartial court. Now, let me now address a few of these points in greater detail, and in particular.
We need to move your slides on.
Yes, we need those because I'd like to make 3 points now, really. The first, I think, is sovereignty. Now, it will be most unusual, of course, any kind of agreement, should an agreement be reached about between Britain and the EU about the continuation in amended form or not of some of those criminal justice cooperation measures, then it will be sensible to have an adjudication mechanism to settle any disputes that are arising under these agreements. Now, a dispute settlement mechanism is a regular feature of all kinds of international agreements, but it is most unusual for any such agreements between various parties to have to consist of anything other than an impartial dispute settlement mechanism. It's most unusual, in other words, that one of the parties submits to the jurisdiction of what is in effect a domestic court of the other party. That is, in a sense, what is often proposed here. The UK leaves the European Union, but submits to what is in effect the highest domestic court of the other party to the agreement, namely the EU. As Professor Spencer said, it will be just as rational, natural, or unnatural for the EU to accept the Supreme Court of the United Kingdom as the supreme arbiter. But for whatever reason, this is regarded as unacceptable, whereas submitting to the ECJ is somehow natural, just because that was the position while Britain was in while she was a member. Now, the EU has something like 50 association or trade agreements with third countries. In none of them, or except in one of them, I should say, does the party to the non-EU party to the agreement accept the jurisdiction of the European Court of Justice. Not even tiny Andorra or San Marino do so. There are It's not working, is it? Dear, dear. Okay, well, I can. Yeah, excellent, very good. Well, there are two exceptions to this. One is the EC-Turkey Customs Union Agreement. That is, in fact, the only one agreement where Turkey accepts to follow the case law or the ECJ in applying the common rules of the customs union. There are very, very specific reasons for that. Otherwise, that agreement simply could not possibly work. Even in the case of the second broad exception, namely the EEA agreement, it's not direct ECJ jurisdiction which is accepted, but the ECJ case law is mediated via a separate court, the so-called EFTA court. So, in the over 50 EU trade and other agreements, there's only one where the non-EU party accepts ECJ jurisdiction. That's Turkey, for sui generis reasons in its customs union agreement with the EU. Not even Andorra and San Marino do what many people seem to be saying the UK should do as a matter of course. Now that takes me to my second point. So it's not only, I suggest, a matter of pride because it's inimical or incompatible with the principle of sovereignty that the UK accept or shouldn't accept ECJ jurisdiction. The ECJ, I boldly but defensively claim, is simply not an impartial court. Why not? It's not an impartial court, it's not a conventional court, it's therefore perhaps not even a court of justice. The reason for that is rooted in in the court's peculiar interpretive approach. It adopts an ultra-flexible and purposive approach which is at variance with the Vienna Convention on the laws of treaty. It doesn't apply the Vienna Convention and its methods of interpretation, even though according to the Vienna Convention on the laws of treaty, any court of any international organization is obliged to. And it follows an interpretive approach based on various non-ordered, non-hierarchical interpretive criteria, literal, contextual, purposive, meta-teleological, and it chooses and favors, it gives the greatest weight to whatever criterion allows it to adopt the most pro-union interpretation of any provision it is looking at. So it's a highly flexible approach. And it allows the court to expand the European Union's competences in whatever area it is adjudicating on. Now, it's highly naive, I think, to assume that whereas the European Union does this, the European Court of Justice does this as a matter of course in its interpretation of the EU treaties, it will adopt a very different approach in any trade agreement or criminal justice agreement with a member state to whom it doesn't even have to accord the respect of a member state. And I'll give you three examples, or two examples rather, of cases which show that the court isn't indeed an impartial arbiter, and that this is not merely a kind of rhetorical boogeyman I'm building up here. The first case is that of Advocaten voor de Wereld, and in this case, the Court of Justice held that Article 2.2 of the framework decision of the European arrest warrant, which dispenses with verification for the requirement of double criminality, a well-established principle of criminal justice in relation to the listed offences there does not infringe the principle of legality of criminal offences. So I think, I'm not sure everyone should be happy with that decision, and that's good law that would continue to apply to any UK-EU agreement if the ECJ continues to exercise jurisdiction. I've gone back on that. And that is the second case here, Meloni. It's a severe restriction of member states' national legal sovereignty, insofar as this decision categorically prevents member states from imposing a standard of fundamental rights, including procedural justice, protection, at a level higher than that under the EU Charter. Now, not everyone may wish to do it, but I think it's quite another thing to say that that this shouldn't even be possible as a matter of national constitutional law. But that is exactly what the Court of Justice decided when the Spanish Constitutional Court referred this question to it. So, two examples of how ECJ jurisdiction, even in that sphere of very limited EU competence, severely restricts national legal sovereignty. And now to the final point I'd like to make. This is an example of what I think is a sensible alternative to Court of Justice jurisdiction, should one wish to continue operating a kind of extensive EU or criminal justice cooperation regime with the EU. Now, since the EU is so awfully keen on the Court of Justice, then the Court of Justice could, of course, continue to be the point of reference for any kind of case with a criminal justice, even reaching it from within the EU. Then there will be a kind of UK equivalent in first instance, and these would broadly speaking deal with a majority of cases. And should there be any divergence of case law between them, then there could be further adjudication by a UK-EU joint treaty tribunal. But that tribunal should be composed in a balanced manner with judges from both parties and in equal numbers. And it would lay down binding interpretations for the EU-UK agreement in the sphere of criminal justice. There's absolutely no reason why such an impartial tribunal shouldn't be agreed. It's perfectly in line with the existing model the EU has followed in practically all its agreements. Now, I should like to stop here, but I should just say that this is basically a very, very rough summary of a paper developed by Martin Howe, myself and Francis Hall, where we talk about this in greater detail. And it's really the kind of model that could work with some modifications, not just for criminal justice agreement, but equally for any trade or withdrawal agreement. So thank you very much.
But I want to thank our panel very much. This is a very serious debate in Britain. We've had this very serious debate for a long time. There are very strong arguments and coherent arguments on both sides, and we have a great deal further to go to resolve it. But we won't resolve it tonight, but we'll continue to discuss it in the way in which you've shown your interest tonight. We'll continue to discuss it, raising the interesting points, trying to reach a solution about these very difficult matters, and how we can reconcile different priorities which people in this country have, and whether there is a system in which sovereignty is reconcilable with cooperation between the courts. And the big question facing us tonight was whether, I think John Spencer put his finger on it, and this was taken up, and Chris Chalk developed it, and Chris Chope gave his opinion, and Gunnar gave an overall view from a German constitutional perspective, as well as a UK one, is the potential conflict of sovereignty and the operation of the courts, and whether one needs a dispute mechanism system in which matters of interpretation, which Professor Spencer mentioned, in which these matters are referred to another body which represents both states to the matter, or whether they are not, whether one or the other is supreme. That's a very big demand on either state, and it may well be that we can get somewhere if we discuss it and we look at other models for the reconciliation, but I don't think that anybody tonight was arguing that there shouldn't be continued cooperation, but how we organise that cooperation, the exchange of data, the very necessary cooperation in a very sophisticated age of cybercrime and all the other dreadful crimes that happen cross borders now, that we do need to continue to cooperate. And I think that's the message, and we've got to organise that satisfactorily for everybody. How that happens will be a matter for Parliament, I think. And so you have a task ahead. But thank you all very much, and I'd like to thank both our parliamentary and our academic speakers. And thank you, Jim.